Good morning and a very warm welcome to this tripartite webinar hosted by Landmark Chambers, Quod and Ashurst. I should say at the outset that when we first advertised this webinar, it was the height of summer and the imagery we used included sun lounges, sunshine, swimming pools. Well, as you can see, that has all been faded out. It's now back to school, and we need to get to grips with the plethora of planning reform that's come out of the government over the summer holidays. Don't worry, we're here to help you. So, what are we going to cover today, and who have we got speaking? I've got a motley crew with me today, and I'm going to ask each speaker to give us a wave when I mention their name. So, I am going to give a very quick overview, followed by the distinguished Dobson, Tom Dobson, who many of you will know is a managing partner of Quod. Tom's going to deal with housing needs, standard methodology, the numbers, etc. We put Tom first as we think this nicely sets the scene for the other reforms. After Tom, we've got the exceptional Elvin, laughing, David Elvin Casey, who will talk about one of his favourite topics, the Greenbelt. This really is one of the new government's flagship reforms. After David, we've got Rave Reviews Reid, Charlie Reid, who is a partner from Ashurst, who will talk about the reform's impact on infrastructure. There's always lots of chat, as we know, about housing, but quite frankly, there will be no housing if there is no power or infra. Last but not least, the mighty, marvellous Maurici, James Maurici Casey, who will deal with what I call the hidden nuggets in the draft NPPF. We all know there's been lots of talk about numbers, green belt, grey belt, but James is going to cover some of the other bits and bobs, which are really still very important. Each speaker will speak for 10 minutes, then we'll have a discussion at the end, so please feel free to post some questions in the Q&A. The session is being recorded and we will circulate the recording and the slides after the webinar. So off we go. Sorry, the slides are very delayed. Here we go. So the title of this webinar is Grasping the Nettle, because that's what Labour said they would do. And boy, have they done it. There's been a flurry of proposed reforms over the summer. Quick off the blocks in only the fourth day of office, the government quickly ended the ban on onshore wind with the stroke of a pen by deleting a footnote in the NPPF. This was followed by the King's speech, where we are promised new law. I think some of us, sorry, is my video still on?
Yes.
Yes, thank you. I think some of us had hoped for no new law. But as we all know, in planning reform, we always get new law to grapple with. However, thankfully, with the Planning and Infrastructure Bill, we're not promised root and branch reform, a tear up of the planning system. The Planning and Infrastructure Bill seems to be dealing with esoteric areas of the planning system, such as CPO, such as NSIPs, stuff about modernising planning committees. Strategic planning, we're promised new law on that in the devolution bill to bring back strategic planning. There's a push on getting elected mayors to produce their own plans, very much like Mayor of London does. But the government is asking for ideas about how we get strategic planning rolled out in areas where there is no elected mayor. So if you've got any ideas on that, by all means, respond to the consultation. On the 30th of July, we got the draft NPPF, which proposes a wide range of reforms, which we will deal with in a minute. And then the very next day, the government issued a policy statement on new towns. It's fair to say there's not a great deal of information on this at the moment, other than it's clear that the government sees one way of meeting its housing target is to produce housing at scale in the form of either new settlements or urban extensions of at least 10,000 homes each. These will be governed by a new towns code, which will provide a set of rules for developers have to meet, including 40% affordable housing. A new task force will be set up by Sir Michael Lyons, and they are going to report on appropriate locations for the new town. Other reforms have been mooted, some of which featured in the wider consultation that was released with the draft NPPF. They deal with a wide range of topics that I've put on the slide there. And all this has been wrapped up in a very clear, strong written ministerial statement from Angela Rayner. There's a lot here, and we don't have a lot of time today. So we today are going to focus on the draft NPPF. This is the centrepiece of the reforms, really. The government sees changes to national policy as a very quick way to push through its reform agenda. And speaking of time limits, we've got just under 2 weeks to respond to the NPPF. That's the deadline there. The government has said it wants to crack on. It wants to publish a brand new NPPF before the end of this year. So against that context, I will now hand over to Tom.
Thank you, Claire. I had the challenge here of trying to say something new about housing targets, something that everyone's been poring over. There have been lots of research notes, other information that's been published since the publication of the new objectively assessed need housing targets. So I thought I'd take the unconventional approach of quoting Britain's leading housing economist, describing what I'm about to talk about as nonsense. I think it's important to bear in mind, and a lot of people have been going down the kind of rabbit hole on the numbers and is this objectively assessed need, are they correct, etc., etc. Whereas in fact, I think the most important point to take from it is that the numbers are there to make sure that local planning authorities plan for more housing and give planning permission for more housing. In that sense, they're kind of a heuristic rather than necessarily a objectively assessed need. But effectively amounting to the same thing. But I think looking at it, it's worth thinking about what are the impacts on people's actions within the system rather than is this the perfect way of measuring housing need, which one can discuss at length ad infinitum as people are doing at the moment. Obviously, for those of us who've been involved in this for some time, this isn't a kind of new thing. We've been around what I'm describing here as the kind of targets hokey cokey, government putting them in, putting them out, shaking them all about. We're back at almost the kind of beginning of the process in 2010 when Lord Pickles abolished Labour's Stalinist housing targets. Then we had the NPPF coming in and saying that authorities should meet fully objectively assessed needs, but not saying what they were. So lots of us sat in town halls around the country arguing in front of an inspector about what they were. As a result, the esteemed local plans expert group recommended that there should be a common method. That was introduced in 2018. Then the white paper and the famous mutant algorithm in 2020 proposed actually turning them into fixed targets. That was quickly abandoned after a backbench backlash, and we ended up with urban uplift. And then in order to get the Levelling Up and Regeneration Act through, Michael Gove changing the NPPF so that they became an advisory starting point. So we've been kind of round the houses on this, as it were, for some time. The Labour manifesto, as we all know, said we will immediately update the NPPF and restore mandatory housing targets. I think the description in the NPPF consultation is actually a more accurate description of that because it makes the standard method mandatory, and then the next step is local authorities planning for those targets, and it doesn't take away from the fact that they could potentially plan for a lower figure, but it's much stricter about how they do that and what constraints they can use. And David Elvin will say a bit more about that in relation to green belt and grey belt. So a quick run through the new methodology. Firstly, The current standard method based on household projections, which change regularly, affordability, which changes regularly, and then the arbitrary urban uplift, effectively to take pressure off Conservative authorities and place them on large Labour authorities. The new proposed standard method changes that a bit. It has the growth based on a percentage of existing stock rather than household projections, strengthens the affordability multiplier a bit, and removes the urban uplift. There are some general implications arising. So the first one is that the overall increase has gone from 300 to 370,000 homes per year in total. And that is about the point I was making earlier about placing more pressure on local authorities. And it has increased virtually all local authorities' targets. There are a few that had urban uplift where they've gone down, but generally it's going up everywhere. So the debate is about the extent to which it's gone up in different places as to whether it has gone up at all. The base growth should be more stable. So we shouldn't have the constant changes about the household projections are going to change and therefore the target might change significantly. But what that's resulted in is an increase in areas which had previously constrained growth, so Greenbelt authorities in particular, and those authorities with flat or falling population, so some of the ex-industrial towns, and there's been some debate about that and how that works. There's been a fall in most urban uplift areas, but if you take a wider kind of housing market area, strategic housing areas, the change has been relatively less. But I think one of the key points from our experience already talking to clients, talking to authorities, it's actually hard to generalise, and you need to go down into the individual detail on authorities in housing market areas, what the numbers look like, where people are planning, what the additional growth has been recently. So it's actually quite granular, even though there are some broad implications. I'm just going to run through very quickly 3 examples without jumping down into the numbers. So Greater Manchester as a starting point, which, as most of you know, the authorities adopted they were individual plans, but a joint development plan, but in practical terms, a joint development plan to meet effectively, I mean, the joint plan target was slightly below the existing method, but about on that level. The new method will push that up, so there will need to be reviews of those targets. And the change against the current method pushes the numbers up, for example, in the one in Manchester, where Manchester, the city, where the numbers are red. But against the current target, and I think this is an important point where people are talking about brownfield first, and we need to make sure we're still doing brownfield first, is that we already were doing brownfield first. So Manchester and Salford were taking much more of the joint plan target than the current method or the proposed method would imply. So I don't think there is a lot of additional that is going to be squeezed out of some of those urban areas. And in that sense, the urban uplift change isn't as significant as I think some might be claiming. Taking London as an example, and it's not really worth looking at the individual numbers, although people have been delving down into them. Because the consultation document says where there is an operative spatial development strategy in place that's less than 5 years old, the STS targets will continue to provide the housing requirement. London's plan was adopted in 2021, so the targets that are in the London plan will effectively be in place until 2026. The current objectively assessed need, including the urban uplift, was around 100,000, but the actual London plan target was around just over 50,000. The proposed number is 80,000, and the actual annual delivery is 37,000. But what that means is that effectively the London plan, the new London plan, and the mayor's just started on a process of reviewing the London plan, is going to have to meet about 60% more, find 60% more housing capacity to plan for, and then allocate it across the individual authorities. So in London, the pressure is firmly upwards. It's not downwards as has been kind of reported in some of the press. And then taking Surrey as an example, but this is probably the same for most Greenbelt places around cities, all of those numbers are going up, and it varies to different extents, but they are going to have to be looking at meeting additional targets. In terms of the implications for plan making, then you take that number, and then the important point here, local authorities will be expected to make all efforts to allocate land in line with their housing need as per the standard method. So one of the, arguably the most key move of the NPPF changes has been to delete virtually everything that was all the revisions that were made in December 23 that weakened the requirement to meet housing need, has placed that back on, and in addition to that has increased the targets and introduced requirements around green belt and grey belt that David will talk about. But there is no kind of easy way out. We can't meet this need approach that is going to be able to be taken now. People are going to have to seriously seek to meet the need. And then I think government sometimes comes in and thinks, well, if we come in, we change the targets, we pull the lever, and then everyone does what they're going to do. Whereas in fact, they're actually kind of shooting the starting gun on a very complicated set of games by over 300 individual local planning authorities who are weighing up the different options and approaches that they can take to responding to that. I'm not going to go through this very complicated diagram, but it's a bit of a mind map if you're a local authority about how you respond to it. Is my number going up? Is my number going down? Do I have a draft plan? Do I have a regulation 19 draft plan, etc.? And the transition rules, the proposed transition rules within the NPPF are quite tight and are intended to make sure that authorities do respond quickly to this. They don't want this kicked into the long grass. But at the same time, what we've seen is some authorities accelerating existing plans which have much lower targets in order to try and bag that lower target and then take the pressure off and have the ability in the longer term to review their plan with the higher number. And given the amount of time it takes to review a plan, hope that government policy changes and they never have to meet the number. So there is going to be a lot of gaming going on and a bit of cat and mouse, I think, between central government and local government over these issues. And then we have strategic planning. That was another part of the Labour manifesto and is a strong commitment from the government, but not quite yet. I mean, as we know, it takes a long time to make a strategic plan, particularly in circumstances where the mechanisms aren't necessarily in place, the legal ones, to be able to do that. So we have a starting point of London, which may be the kind of exemplar. It already has a strategic plan. It's about 20% of the national target. So the revised London plan should be doing that strategically. The government is talking about giving the combined authorities similar powers. Some combined authorities have powers to make an SDS in the same way as the Mayor of London. Others don't. The government's looking, I think, at levelling that up, but that will take some time. And then we've got the non-combined authorities where we have large unitaries, voluntary groupings, nascent combined authorities, which is about half the national target. Many of those do work proactively. I know, for example, the Leicestershire authorities planned proactively, did all the things the government wanted, are moving forward on the basis of the previous targets for meeting that. So you don't necessarily need new powers to do it. You just need a willingness and a commitment to cooperation. But there are places where there probably will need to be stick as well as carrot. But I think that the message from the government is just get on with it now. And we'll hear from James about the duty to cooperate, which is not as dead as it was intended to be previously under the previous government. So there's a lot to kind of go on there, but I think the focus from government is get on with things. London, as an example, was the previous plan, although it was adopted after the standard method, it didn't use the standard method as a starting point. It used its own need assessment. It then went through an examination process where the panel recommended a reduction in the target. It will be interesting to see, given that they didn't think there was capacity for 65,000 homes in 2020, whether they think there's capacity for 80,000 homes in 2025, but the mayor's going to have to strive to meet that. So capacity assessment, probably a green belt review, and a process of strategic planning working through that. And then lastly, the kind of implications for applications, because on the one hand, I think the government does want to see the strategic planning, proper sustainability, homes in the right places, etc. But at the same time, I think it sees the need for a kind of stick through the development management process for those authorities that don't seek to meet that need. And therefore, there are going to be significant impacts for applications, particularly after the NPPF is introduced, and the housing delivery test has been kind of returned to the status quo ante prior to the kind of Gove reforms. And what this diagram shows is just what the change would look like if you imposed the new targets immediately on the individual local authorities. It's illustrative because obviously the housing delivery test is quite complex, and authorities with up-to-date plans can use their existing targets and so on. But at the kind of extreme, you would go from 60 authorities to nearly 150 with the presumption applying, and only down from 194 to 74 that have no housing delivery test kind of outcome where they have to do something. So this is something that's potentially really coming down the line. So again, strong incentive on authorities to plan, make, but also for developers and applicants to think about what's going to be happening next over the next 2 or 3 years. And then all of this feeds into the other reforms. And I'm going to hand over now to David Elvin, KC, who's going to talk about the draft NPPF and particularly Green Belt and Grey Belt. Thank you.
Thanks, Tom. Let me just get hold of my slides. Yes. I'm going to whiz through this, but I'm going to start just by pointing out the key Greenbelt policies currently in the NPPF, which have by and large survived largely unamended in substance since the original NPPF. Those particular key aspects of Greenbelt aren't proposed to be changed in the NPPF. There isn't a fundamental change. What you've got is a tinkering or an amendment of certain elements of it, in particular the basis for review and also the new development, not inappropriate development category of PDL and Grey Belt. Some statistics there just to point out that contrary to previous trends, Greenbelt has actually been growing over the last couple of years and of course stands significantly greater than it did 30 years ago. And it's about 12.6 of current land coverage in England. If you see here the authorities with the greatest amount of green belt, not sure why York's in that list since the local plan process has yet to complete, but never mind. Here you've got the net changes over the last 10 years, and you'll see for both 2021 to 22 and 22 to 23, in fact, Greenbelt has grown rather than following the trend in previous years of shrinkage. And it's not entirely down to local plan adoption, because you can see the number of local authorities undertaking reviews is not significantly different in the last 2 years to what it was in the previous 8 years. This is an important statistic in my view, because you can see for non-developed Greenbelt land turning to developed use over the last 10 years, the majority of the land that was in the Greenbelt that has been permitted to be developed is not previously developed land. 71% of land in the Greenbelt which has been developed has not been PDL, which perhaps gives us an insight into what the new effect of the new Grey Belt not inappropriate development category may have. You've got the Chancellor's speech. Claire's already dealt with that. The reference to the Golden Rules, followed by the Deputy Prime Minister's letter, which accompanied the NPPF on the 30th of July. I find it rather difficult to understand what's going on there, because the Deputy Prime Minister, I don't think, was rightly briefed, because she seemed to equate Greenbelt with potentially having environmental value. But in fact, the consultation document makes it clear that it's not an environmental designation. And of course, those of us who've been dealing with it for decades know that it's a strategic planning designation, not a landscape or environmental designation. But Deputy Prime Minister goes on as if it were. However, there it is. The concept of Greenbelt was introduced and the Golden Rules. The issue is going to be largely left to local authorities to judge what is suitable to be decided to be Green Belt, and Grey Belt is Grey Belt. And grey belt is in essence a green belt site which performs poorly against the objectives of the green belt. But that is not, as I've said at the bottom of the page, clearly explained, and certainly not done in the draft proposals to the NPPF. And in the consultation document, it doesn't really tell you very much other than a restatement of little contribution. And it just basically goes through the 5 purposes, saying makes little or no contribution to each of those purposes. So it doesn't tell us very much. The Greenbelt review criteria, the basic structure remains the same. It's still intended to be difficult to amend Greenbelt boundaries. They're still meant to be enduring. And you've got to have pursued all other reasonable options. But exceptional circumstances are redefined, cannot meet its identified need for housing, commercial or other development through other means. But it doesn't, on the face of it, impose a lesser test in terms of the requirements for review. There is a sequential approach. First consideration to PDL. Well, we've seen how little PDL has actually been part of Greenbelt development over the last 10 years. Then Greybelt land, and only then other sustainable Greenbelt locations. And this ties in with the proposed development management changes. But that also is tied in to the golden rules, which I'll come to in a moment. We have these curious categories of not inappropriate development, i.e. development which is capable of being regarded as appropriate. The PDL criterion, which is currently 154, is amended to create only one criterion of not cause substantial harm to openness. There's no longer going to be a requirement to have no greater impact on openness than the existing development. So that's intended to relax that a little. Grey belt is defined, I've already mentioned, limited contribution to the 5 green belt purposes and PDL, but excluding areas or assets of particular importance. Those are heritage assets and the like, which are footnoted to paragraph 11 of the NPPF. There is tension because there are several tests in both the development management and the review policies. Development management, substantial harm to openness, you see in the new 151, not by reference to the 5 purposes, but the definition of the grey belt includes PDL, which has to be determined by reference to the 5 purposes and not by impact on openness. And the exception refers to fundamentally undermining the function of the green belt across the plan area as a whole, which appears on the face of it to be a much weaker test than considering substantial harm to openness. So we have the new not inappropriate grey belt development, sustainability, of course, sustainable locations, not to fundamentally undermine the function across the area of the plan as a whole, as I've mentioned, can't demonstrate a 5-year supply, or there is a demonstrable need, and you meet the golden rules. It's not very well drafted. The 3 requirements don't appear to be clearly cumulative, but they presumably are, because they tie in with the Deputy Prime Minister's letter accompanying the NPPF, which clearly sees them as all needing to be met. So we get to the golden rules, which will make life interesting. In the case of housing development, golden rule A is at least 50% affordable housing, subject to viability. There's a sting in the tail of subject to the viability, which I'll come to in a moment. Necessary improvements to infrastructure, and then new or improved green spaces which meet a particular defined standard, and then additional guidance on viability in Annex 4. So there are 3 golden rules for housing, 2 for other forms of development. Viability is specifically defined for the purpose of green belt. It does not tie in very easily to the PPG definition of viability. You've got EUV plus a reasonable and proportionate premium for the landowner, which is actually more generous than the PPG measure of viability. But here's where the oddity comes in. It's suggested that a benchmark land value is going to be inserted to allow an appropriate premium, but then says local planning authorities should set benchmark land values informed by this and by local material considerations. It's very odd, the idea that you might have a nationwide benchmark land value, when, as we all know, values vary very widely from area to area and from region to region. if you can't show that you've transacted your land at benchmark land value and can't deliver policy compliant development, you are normally refused. You don't carry out a viability assessment if it is policy compliant, and you can only undertake a viability assessment, it appears, where the land is transacted below the benchmark value but still can't deliver policy compliant development. And that's slightly odd. I mean, it's below benchmark land value, not at benchmark land value or below. But it means that viability assessments are much more constrained than they would be under local plans at the moment, or under the PPG, where, of course, you can say, well, policy compliant is always subject to viability, and therefore the percentage should vary depending on the viability assumption. And of course, there are restrictions on benchmark land values in that context, but this seems to go a stage further. So, turning to the brief issues, do the criteria for Greenbelt release really give you that much additional scope for flexibility, or is it simply intended to be an encouragement or a prod to local authorities to adopt a more rigorous approach to Greenbelt boundaries, where it can't find sufficient PDL? And statistics rather suggest that may well be the case, given the little proportionate amount of PDL that's been released. Clearly, there's a lot of judgment for local authorities, and that, of course, has been an issue in all housing development over recent years. Now, it may be assisted by universal coverage of SDS, but it may not be speedy. As Tom has indicated, SDS is as yet to be made clear, and the government's paragraphs 27 and 28 of the NPPF don't really say very much, except they're going to introduce universal SDS. And it's going to be used to coordinate a number of matters and to achieve consistency. What it doesn't appear to be intended to allow is to have wider strategic reviews of Greenbelt boundaries. That will still be left to local authorities, which introduces particular problems in coordination in metropolitan areas where there's, like London, where you've got an overriding plan. And the fact that PDL has failed to deliver in recent years rather suggests that the grey belt exception is going to be more directed to the lower functioning green belt land rather than to PDL. Does it, in that event, actually give a local authority much more in terms of review than it already had? Because greenbelt reviews, you always have to consider the functioning of a particular area of greenbelt against the purposes and its strategic value. And the references we've got to car parks and to industrial areas, those seem to be more targeted to PDL than greenbelt purposes. And of course, some of those PDL may not directly affect openness. However, it's not clear. And as I've already mentioned, there aren't clear, consistent references to how you deal with the impact on the green belt. We've got alternative references to purposes, openness, and to not undermining the green belt in the plan area as a whole, all of which have a different level of difficulty to achieve. Much is going to depend on the incentivization, what I've called the carrot and the stick, to bring forward reviews of the local plans and achieve higher housing. And this seems to be a process which is unlikely to be speedy. I've mentioned the SDS, so I don't need to repeat that. The golden rules, of course, are likely to slow the process since there may be issues with viability. And I really just want to deal with that as the last point. Viability, as I've said, doesn't match the current PPG approach to viability. You've got this oddity of appearing to want to set a benchmark land value at a national level, although it leaves it then to the local authorities. So you can see lots of battles going on in local plan examinations. And you've got the problems of landowners who've acquired land in excess of benchmark land value. If you can't, if you've done that, you can't use the viability assessment to justify a lower amount of affordable housing. And as I've already indicated, the wording is curious because it has to be below benchmark land value before you can have a viability assessment. And then finally, of course, this may tie into the CPO compensation reforms, which look to strip out development, appropriate alternative development, i.e. development value, and to set things at existing land value. This has problems in terms of depriving potentially owners of market value. That's another argument to be had. And there's a disturbing trend in that the consultation document refers to representing a transfer of value from public to private landowners. Well, the only reason there would be a transfer of value from public to private landowners is because the government has artificially set a low benchmark land value in policy. The way that this will play into planning material considerations in Section 106 agreements is an interesting question, given the views of the Supreme Court in the LSIC and the Wright cases, and seems to underplay the issue of value and the taking of risks. Finally, I just say, in the light of all of these matters, I really wonder what the prospects are of actually getting through these reviews and achieving the policy position the government wants before the next general election. I'll now hand over to Charlie. Thank you.
Thank you, David. Just make sure I've got hold of my slides as well. I think so. I'm going to talk briefly about energy security and tackling climate change, because they've always been up there with housing for this government, and they continue to be hardwired, that's an intended pun, into the policy objectives set out in Chapter 2 of the current consultation document. I've summarised what those policy objectives are on the slide, so I won't run through them. But the reason why I think it's important to have this in mind is, firstly, so you can understand the NPPF in the round, but also so you can understand how the NPPF fits into the wider package of planning reforms and how that in turn supports the government's broader agenda. As Claire mentioned at the outset, in terms of renewable energy, the Chancellor's already grabbed all of the headlines by lifting the ban on onshore wind in England back in July. The two pesky footnotes in the NPPF were disapplied with immediate effect by way of a written ministerial statement. And this slide just quickly shows why the government was so keen to act quickly. As we all know, planning applications for onshore wind fell off a cliff in 2015 as a result of those amendments to the NPPF. The reason why I'm kind of flagging this to you, though, is I think it just shows and serves to emphasize the power and the influence of the NPPF. So presumably, if the brakes can be applied to development so effectively, the hope must be that they can also be released as effectively to encourage development to come forwards. So what's actually in the NPPF? Well, unsurprisingly, it incorporates the changes that were secured by way of the July written ministerial statement. And you can see that on this slide by way of all of that red strike through at the bottom there, deleting the footnotes. And this is really good because, firstly, it puts onshore wind on the same footing as other forms of renewable energy development. And also, just from a practical perspective, I think it's really positive that there hasn't been a time lag between the July statement and the updated NPPF. We've got everything now in a single consolidated place. But the point that I want to stress to you, I suppose, is that the changes go much further than simply lifting the ban on onshore wind. In addition to that, we get changes to the substantive policy to which the pesky footnotes had been ancillary. And in summary, those say that local planning authorities should support all forms of renewable energy and low carbon development in a general sense. And specifically, when they're determining planning applications, local planning authorities must give significant weight to the proposed development's contribution to renewable energy generation and a net zero future. Those track changes are shown on the slide. And in addition, edits have been made to the plan making provisions. I think that's paragraph 160 of the NPPF, which say that LPAs are now required to identify land for renewables rather than merely considering whether to. And we've also got a much more proportionate emphasis on the contribution that community and small scale developments can contribute. So taking a step back and looking at all of this in the round, I think you've really got to think about what the government's broader objective is: to support and achieve net zero and support energy transition. A large contribution is going to be made by nationally significant infrastructure projects. Those projects have the benefit of National Policy Statement EN1. That establishes an urgent need for such projects and directs the decision maker to give significant weight to that urgent need. And so what we now have, you can see in the NPPF for local planning, so there'll be a meaningful contribution to the energy transition through local planning applications, is a much stronger presumption in favour of all forms of renewable energy projects. I think this goes more or less as far as an NPPF can, obviously without going as far as EN1 can for NSIPs. If I was going to make a passing reference, though, on the drafting that's out for consultation, it would just be to pick up on that word generation that you can see in paragraph A there. I think this potentially limits the reference to generation assets, but it's been talked about very widely in the press about the need to update the national grid to get this electricity around the country where it needs to be. And I wonder just whether that paragraph A could be improved by expanding the text to include references to distribution, transmission and supply alongside generation. That covers the kind of main meat of what's in the NPPF renewable energy, but I'm just going to really quickly canter through the other smaller bits that are relevant to this sector and infrastructure. Firstly, infrastructure to grow the economy. There's much greater support for commercial development generally at the NPF, particularly the uses on the slide there. I'm not going to talk about it in any great detail because happily for you, James is going to cover it in the next section of this webinar, but I would just quickly flag that there's really helpful references into the drafting that James will take you through to supporting infrastructure like grid connections, and I think this can only be a good thing. On climate change and the environment, there's nothing really expressed in the updates to the NPPF, but there are a handful of really quite open questions in the consultation to consider, such as what else can planning policy do to improve climate or address climate change mitigation? Are we ready for carbon accounting? And do we need to protect habitats that capture carbon? On the carbon accounting, I'm a bit wary of that. We've already got viability that David talked about. We've already got biodiversity net gain. Could this be another complicated, contested technical area that slows down planning? Thirdly, on public infrastructure, no surprise really, given the election pledges to fix the NHS and the criminal justice system. So we've now got a direction to apply significant weight to the importance of upgrading infrastructure like hospitals and prisons. And I think this is only going to serve to help the government deliver on its pledges. There are changes in the NPPF on sustainable transport. Again, I'm not going to go into any detail because James is kindly going to take you through all of that. Agricultural land, this is quite techy, but it's really, really relevant to renewables, especially solar. Wording was inserted into the NPPF back in December 2023, so not that long ago, basically making the availability of land for food production an express consideration for whether land should be made available for development. And that's now been deleted. The government thinks the issue is captured elsewhere in policy. And finally, grey belts. Dave has just talked at length on this, but I just wanted to remind you that whilst all of those changes about green belt and grey belt have been clearly written with housing in mind, they do create an opportunity for other forms of development, and energy development could arguably fit within the wording. And I say this within the context, of course, of the first call-in decision of the Secretary of State being for a solar farm in the green belt. So I've covered everything that's in the actual updated NPPF document itself, and I'm now just going to importantly run through the other things that are in the consultation that go beyond the NPPF document itself. Firstly, the government's asking whether or not onshore wind should be brought into the DCO regime. It had been in there when the regime was set up, but it was taken out in 2015 with those footnotes in the NPPF. And I think its reintroduction would just completely complete the rehabilitation in planning terms, of course, for onshore wind. Can't see a reason why it should be excluded still. Linked to that, though, is the question of at what scale should onshore wind be reintroduced. In England, of course, there's a 50 megawatt threshold for electricity generation stations. Above it, you're in DCO territory. Below it, you're in local planning. The government's proposing a threshold of 100 megawatts for wind, and it's also proposing to increase it for solar to 150 megawatts. This is supposedly to address market distortions and to capture improvements in technology, but I question whether this is really going to solve a problem or just move it elsewhere. And I would suggest that potentially a better way of thinking about this might be to ask what amount of electricity actually would make a project nationally significant and therefore able to benefit from the DCO regime should it need to. Thirdly, the government's asking whether it would be helpful to include data centres, gigafactories and laboratories in the DCO regime. This would be by directing into the regime under Section 35, and it kind of sits with the wider reforms to the NPPF I just touched on. It's a bit of a curious one, if I'm being honest. We've had regs since 2013 that enable business and commercial projects to be directed into the regime, and it's really barely been used. I think I can only think of about one project that has tried to follow that route, and even that got withdrawn. I think ultimately this all really depends on what type of consent a project needs. I think most of these types of projects, like data centers and laboratories and the like, are likely to just be normal development projects, and they don't necessarily need all the bells and whistles, costs and profile that comes with a DCO. So there may be low take up. And arguably, I'm not 100% convinced that legislative reform is needed. Arguably, the existing regulations could work for those types of projects. Fourthly, the government's looking at changing the thresholds for water infrastructure. This gets techie really, really quickly, so I won't go into detail, but it's all about trying to increase the scope of the NSIP regime and improve water resilience. And lastly, the government's asking whether or not local authorities should be able to or entitled to recover their costs when acting as statutory consultees for NSIP applications. No doubt this is going to be well received, although there's some wording in the consultation document, just to draw your attention to it, that suggests that the planning performance agreement regime isn't going to be entirely done away with. So that, in a nutshell, covers everything that's both in the updated NPPF as well as what's alongside it. And in my last slide, I just wanted to bring your attention to this quote because it really jumped out at me actually when I was reading the consultation document. And I'm sure that most of you in the industry and on this webinar will probably agree that this is some kind of planning nirvana. We'd all be supportive of it. But the question I suppose that I would leave you with is whether or not the current and emerging planning reforms as we understand them will actually achieve this. I suppose my concern is that with all the discussion around NSIP thresholds, is that possibly we're not going to end up with projects having sufficient flexibility to choose the optimum consenting route for a specific project. So thank you for listening. That's all I have to say on energy and infrastructure, and I'm handing over to James.
Hi, thank you. I don't seem to be able to switch my video on, so I don't know whether someone can help me with that. Yeah, got it. Thank you. So I'm covering everything else that's in the NPPF. So first of all, in terms of changes, the presumption, two changes. One is on the application of the presumption, the change from that being triggered by the policies which are most important for determining the application being out of date, changing to it being triggered by the policies for the supply of land being out of date. And we have a definition now provided in the footnote of what policies for the supply of land are. And the second change is to the adverse impacts test in 11D2, which now adds the words when you're looking at the benefits and disbenefits, you in particular look at location and design of the development and securing affordable homes. So why is all this changing, first of all? Well, I think in relation to the change of when the presumption triggers, what the government is really suggesting is that they're trying to bring clarity because there's been extensive debate and litigation about what policies most important are, and I'll come back to that in a moment. The second change is said to be driven by the fact that some developers have apparently used the presumption to promote low quality, unsustainable development, and they're trying to add an explicit reference to avoid that consequence, or at least the perception, I guess, of that consequence. So what are my thoughts? Well, the first change, I think the aim, clarifying the position, is admirable, simplify when the presumption arises, but has changing the text of paragraph 11 ever reduced the scope of arguments on appeal and in litigation? I think the answer is quite clearly no, and I don't think this will either. I suspect it won't be too long after this comes in that the High Court and the Court of Appeal will be wrestling with the issue of what is a policy for the supply of housing again. So good intention, but probably won't achieve the aim. The second change is interesting. I mean, in the end, I think really it's just about perception. I don't think it'll make much difference the way the test operates. So I think it probably won't leave us in much of a different world. So that's the presumption. The duty to cooperate. So as Tom said, we thought it might be dead or dying, but it seems to still have a big feature here. There are two things that are going on really in these paragraphs. One is there's really a sort of dealing with the future, i.e. the return of strategic planning. But secondly, there is also quite a lot that's been added about the need to cooperate in any event in terms of plan making. And it's interesting, if you look at the consultation paper, it explains why the duty still has some life in it. I mean, first of all, while it's going to go for the reform plan system, it remains a legal requirement, obviously, for current plans and any plans that are progressed under the current system. And in addition, of course, we're reminded new legislation is coming that's going to provide for cross-boundary strategic planning. But in the meantime, there is still a need for there to be effective cooperation. So the duty to cooperation is not quite gone. In any event, there is a need to cooperate as we move towards a world of strategic planning, or return to the world of strategic planning. Now, economic development, again, this is an area where there are quite a few changes. I've obviously included here all of the highlighted text, and I think that text is all really useful in terms of the promotion of any development that falls within these areas. And I think what's interesting is that while a lot of the focus to date has been on the housing, I think these changes towards driving economic development are really important. So the consultation paper says the NPPF is proposing changes to the plan to drive greater commercial development in these sectors, and that includes laboratories, gigafactories, data centres, digital infrastructure, and the facilities needed to support the wider supply chain. All of that hugely important. Great that we've got this extra drive towards it, all of which no doubt can be used to boost the economy, no doubt, so it can then be taxed further. We'll find out on the 30th of October. Beauty no more. Well, they say beauty is fleeting or temporary, but nothing quite as fleeting and temporary as the beauty changes that were introduced in December 2023. Largely derided and ridiculed when they were introduced. They're going to have a very short life and they're going to end. The government, I think, makes a very sensible point in the consultation paper that really it's gratuitous and unnecessary, and we're better off focusing on good design. Interestingly, there's been a little bit of backlash about this from certain groups. There's a right-wing think tank that urged Labour not to drop beauty, but I think it's undoubtedly right for the government to ditch this unhappy set of provisions. Schools and other public infrastructure. Again, a lot of sort of changes of emphasis really about the importance of early years and post-16 education, which I think is interesting for all kinds of other policy reasons. A real kind of push to have more nursery places, and then as Charlie mentioned earlier, a general provision that significant weight should be placed on the importance of new, expanded or upgraded public service infrastructure when considering proposals for development. So it's not just obviously about schools and education, but obviously also about hospitals, criminal justice system, etc. This is all now going to derive strong support from national policy in order to seek to deliver such public infrastructure. And then I come to transport, which is a sort of penultimate thing that I was going to cover. I mean, I think in many ways these changes are the most interesting of all. There are really two aspects to it. One is the introduction of what is called a vision-led approach, and you'll see that is mentioned several times within the new text. But secondly, then a change to the severe test to say that you will only be refusing where the residual impacts on the road network will be severe in all tested scenarios. Now, the vision-led approach, I think, is welcome. The consultation paper pitches this as an abandonment of the old predict and provide pattern, challenging, it says, the default assumption of automatic traffic growth and assessing the worst case peak scenario, and then dealing with that. It seeks to replace that with this very positive sounding vision-led approach to transport planning. All of that hugely sensible, sounds great. I mean, obviously devil in the detail, but the proposed change to the severe test, I think, is a bit troublesome. I mean, probably we must look at it in the light of the important thing, which is the introduction of the vision-led approach. But can it really be said that national policy is going to sensibly say that you only refuse if the transport impacts are severe in all modelled scenarios? I mean, really? That makes the choice of the modelled scenarios rather important. I mean, can I model on the basis that my 2,000 home scheme will only generate a handful of trips by car because of my great vision towards better transport? So I can see the sense of it, I can see the thrust of where it's going, but I think it could be troublesome, and I suspect the drafting will have to improve significantly to make this work in any kind of sensible way. So briefly, some other proposed changes. You'll remember that the previous Secretary of State was truly obsessed with mansard roofs for reasons I do not understand. They still remain, but a lot of the detail and emphasis has been taken out. Their inclusion in national policy sticks out like a sore thumb, really. I don't know why we're talking about them all the time, but they're still in there, but the detail's probably gone, and probably the emphasis. Some helpful deletions on in paragraph 129 about the inappropriateness of significant uplifts in local density. That was another December 23 revision that's thankfully going to be killed early on. And similarly, as Charlie mentioned, I think killing off the express mention of food production is another positive thing. And there have been some DCA decisions since the new government came in, which have sort of put food production in its place in terms of where that sits in the planning balance. And I think that takes us all through to the end and some discussion. Claire.
Great, thank you very much indeed to all the speakers. We've got a couple of minutes left. I've got two very good questions that have come in, actually. The first one I'm going to direct to James. What reliance, if any, can be placed on the proposed changes in the NPPF at the moment? It's a good question because many clients have asked us this one.
Yeah. So I mean, I've been sort of posting on this on LinkedIn recently, and I mean, I think the position is quite clear from both case law and the emerging appeal decisions that we've had since the draft NPPF came in. The actual changes to the policies themselves, the detailed drafting and the detailed changes, I think limited weight at this stage because it's still subject to consultation and it could change. But both the ministerial statement and the draft as a direction of travel are a material consideration which can carry some weight.
Right, okie doke. Another person has asked, given the definition of grey belt includes PDL, is there a distinction between the level of affordable housing likely to be sought on PDL sites as opposed to grey belt sites? So, David.
That's a very good question because, of course, as you say, grey belt includes PDL. But there remains a separate category of PDL in what's currently 154 that I mentioned in terms of relaxation. On the face of it, the 154 to be 151 PDL, not inappropriate development, does not carry with it a specific golden rule about 50% affordable housing. But if PDL is to be included in the definition of grey belt, then it allows the local authority to say, well, this is actually a 152 development, I suppose, with 50% than a 154. It doesn't actually grapple with the overlap between the two. So I agree, it's an uncertain issue. But I would imagine if local authorities are going for the 50%, they will treat it as a 152 application rather than a 151.
Yeah. Grey belt, green belt, certainly popular for the questions. Is metropolitan open land, which of course has the same status really as green belt, is it at risk of loss through these proposals?
Well, if the mayor, well, given that the London plan effectively is London internal green belt, as you say, if the mayor takes the view in the next review of the London plan that it ought to be guided by changes in green belt policy, then that could be the case, particularly if London's coming under greater pressure for increased housing numbers, as Tom indicated.
Yeah. Question for Tom Dobson. This is a good one. Will the targets be achieved? You're on mute, Tom.
As a starting point, obviously, I think the numbers are still, or the most recent numbers are still going down rather than up. So I think it will be a challenge, and probably in the end, the government will be pleased if it can get consistent rising numbers over the next 4 or 5 years, heading towards the target. I don't think they're going to do 1.5 million in this Parliament. And the 370,000 target, the housing target, is obviously above what would be necessary in an individual year. So I think it's going to cause some questions for how government later implements housing delivery test as well, in the sense that the target is intended to give a kind of surplus as well. So I think it's going to be a very hard job, but at the same time, it's intended to, as I say, drive more land being brought forward and more planning permissions being granted. And we will test the theory that it's planning that's stopping us achieving the target on its own, which I don't think many people agree with.
Great. Right. I think the hour's up. We're at the end. So if you have any questions, please feel free to reach out to any of us. Thank you for joining. We'll circulate the slides in the recording. Many thanks for watching, and thanks to our panelists, and enjoy the rest of your day. Thank you.